Friends, we are going to start now. Today is the 262nd Friday group meeting. The topic is Shifting Principles of Human Rights in Indian Criminal Laws. The speaker is our beloved senior advocate, former judge, Ms. Anjana Prakash ji. We are highly grateful to you, ladyship.
Thank you.
No
leadership.
Long, I mean,
I'm no leadership, I'm just an ordinary person, sorry.
yeah. We are highly grateful since we have a lot of glamour also here. What I
Oh
know
my
after
goodness.
circulation, see the
Thank
crowd,
you.
how
Maybe
much
my
I mean.
clothes. It's my clothes which make me glamorous.
Now I request Monica Srivastava will say few lines about today's speaker.
Thank you, sir. Anjana Prakash is a senior advocate at the Supreme Court and a former judge of the Patna High Court, an alumna of the Patna Women's College. She was studied at the Bhagalpura University. She practiced at the Patna High Court and rose to be among the rank of the topmost criminal lawyer in that court. She was the first woman to be evaluated to the position of senior advocate at the Patna High Court, among with the Justice Seema Ali Khan. During her time at the Patna High Court, she was known to be an astute lawyer with a kind heart and a jovial attitude, always ready to help people who needed legal aid and advice the most. She was especially interested in child rights and civil liberties and acted as amicus curiae in multiple matters. She was appointed a judge of the Patna High Court in 2009 and served till her retirement in 2016. She has been practicing at the Supreme Court since then. A victory of greater accountability in the government and the judiciary. Prakash ma'am has been a vocal critic of the application of Unlawful Activities Prohibition Act and an advocate of gender parity in the judicial and outside it.
Thank you, Monica.
Thank you so much for such an elaborate introduction. But unfortunately or fortunately, fact is that I don't identify with the introduction that you've read out about me. I still feel as though I'm a beginner in law and still trying to make sense of whatever is happening. And it's a very, very difficult for me. Even now, I think it is a big, big challenge. So I just hope, after having heard my introduction, which sounds very impressive, no doubt, you guys don't expect too much from me. I'll just think like one of you, and we'll try to explore what are the problems which are ailing the criminal law right now on account of the shifting principles of human rights. So actually the one thing that one must understand is, or correlate with criminal law is, what exactly are human rights? Evidently there are two types of human rights. One which one person is born with, that is inalienable, and the other one which is granted by a political state. As we know these days, I mean, like in the modern times, every state has its own dynamics. Every state has its own list of do's and don'ts for its citizens, and the rights and duties, etc., etc. By way of a constitution, sometimes it's written, sometimes it's unwritten, but there are certain principles which have to be followed in each state. Now there, the human rights which are spelt out, they are ensured to some extent. So in a political state, what happens is whenever there is a dispute between whether or not a certain act of the state falls within the deprivation of human rights, the courts usually act as an arbiter, and they say that, well, this is a violation of human right or not a human right, or not a violation. So we're not talking about a political state right now. Let's start with what the fundamental rights which are inalienable. According to me, the motto or the dicta or the demand of people, which we very commonly say here, roti, kapda or makan. This is something which is a totally, basic fundamental right of every citizen of India. So, where roti, kapda, and makan are concerned, where roti is, of course, I mean, it means a right to livelihood, a right to food. So, when right to livelihood is stretched to a right to food, etc., that is once again, the courts have functioned as an arbiter to say, this much liability is there of the state to ensure that its citizens get rights. So, the Food Security Bill, Act, etc., has come into place. Where Makan is also concerned, there are lots of government schemes which have come up for providing shelters for every citizen, so they say. And because we have to remember, that India is supposed to be a welfare state, and therefore it is the state which is liable for ensuring that these three things, roti, kapda or makan, they are ensured to every citizen. Now when we talk about kapda, that is the main thing, what exactly does kapda means, or a cloth? What does it mean, the right to wear clothes? Does it only mean to cover your body? Or does it mean something more? As I look at it, I would think that it means something more, and it actually means, a right to dignity. Because if you don't cover your body, what happens is that you're exposed. And when you're exposed, you feel undignified. So that basic right, it extends to the physical requirement of a cover. When that is said, the physical being is not difficult to understand again. It's what you require to be a dignified human being. What else is required? Courts have said that, again, I would say that the right to privacy also comes within a right to a dignified living. Because unless you have a right to privacy, obviously it's like covering your clothes, so you have privacy. It's the same thing, you have privacy, and therefore, there are privacy in conversations, privacy behind the doors, etc., which are also inalienable. But as I look at it, I would think that there is one thing which is very essential for a human, for a human dignity, and that is a right to be trusted. I need to be trusted when I come and tell you that I am Anjana Prakash or I am wearing a blue sari. I need you to trust me that I am correct. Now, what does it mean? What does in effect does it mean when I say that I have a right to be trusted? I would say that it means that I am to be presumed to be truthful on certain matters. That presumption is the first thing that you are supposed to draw. And when you draw that presumption, then what happens is that first step of a trust between two persons is established. And that right I have as an inherent right, inalienable right. And when I say in a court of law that what does this presumption mean? The presumption to be trusted, absolutely. It means that when I am brought before the court as an accused and I say that I am innocent, I am to be presumed that I am innocent. That's the first line that the court and an accused has to draw, or the prosecution has to draw. So I would think that the most important right defined under the right to kapda is this, that I should be presumed to be innocent. Only then, unless I am presumed to be innocent, that my right to dignity will be violated. Now, how have the courts dealt with it? This is also very, very interesting. As it has been brought to, it has actually been, we've been brainwashed into thinking, that these Indian laws, they came from British origin or English origin, and therefore they were oblivious of the social conditions here, and it was more like an imposition of the English laws upon the Indian, subjugated majority. But when you look, with a little bit of understanding of law, you find that the Evidence Act, which was enacted in the year 1872, and the CRPC, which was of the year 1874, both these acts together, they defined, the a criminal trial, an ordinary criminal trial. Now, Evidence Act 105, Section 105, burden of proof, says that who is to be burdened with proof of an accusation. It is the party who brings such an accusation has to bring it to its hilt. Now suppose that, now just look at the times that we're talking about. This is 1872. It is at the height of the British empire, when there was a master and a servant relationship. That was the time that the master was giving certain rights to a servant, and that right was that you are to be presumed innocent till such time as the accusation has been brought to its hilt by the person who accuses you. It's a very contextual thing, according to me, and therefore subject, anybody who is even a little bit of interested in criminal law needs to understand, these nuances. That how have we differed, from all this. Similarly, in Code of Criminal Procedure also, if you see, you have a right to a hearing. There is a right to charge, that you're heard on charge. After that also, there are various ways, or one would say, where you put, some kind of a nut and bolt, that this is how you ensure that no person is disadvantaged. Everywhere in the whole of criminal trial, this is what was there. In this context, what happened was that even when India was given a good criminal law by way of its procedure, IPC and the Evidence Act, England was still floundering. They did not have an Indian Penal Code. They did not have a Code of Criminal Procedure. They did not, go by the Indian Evidence or by the Evidence Act, etc. The rules were there, but not as formalized as they should have been as they were in India. In this, what happened was that in 1935, there was a case called Wilmington. There was a boy, Wilmington, who had recently been married. And he went, his wife went away to live with her parents, and she was pregnant. Now this Wilmington, he was madly in love with his wife. So, and he really wanted her back, but she just wouldn't come back. So he went and tried to get her back. But something happened, and in that, the gun fired, and it hit this girl, and she died. So the charge was of murder. Wilmington said, no, it was not murder, I didn't intend it. Actually what happened was that while we were discussing, etc., and while there was snatching, etc., then the gun went off, and therefore I accidentally hit, and I did not commit murder. Now this person, Wilmington, he got convicted by the courts below. Again and again the jury also convicted him. Then there's a long story. Something happens. I don't really know their hierarchy of laws, courts, but it went to various lower courts and all that. When it went to the House of Lords, they said that in fact, the jury misdirected itself by not pointing out, by not being cognizant of the fact that Wilmington had a right to presumption of innocence. And that was something that was denied to him, and therefore the entire trial was bad, and it was set aside, and he was acquitted. Ever since then, since 1935, been following this law of right to presumption of innocence. When we won our independence, after that in 1948, United UNDP-DR, it came into Universal Declaration of Human Rights. 40 countries they drafted this in the UN. whereby once again, they gave themselves one article wherein they said that there was a right of presumption of innocence. This happened in 1948, and thereafter, of course, our constitution came into existence, and Article 23, which says that no person shall be compelled to be a witness against himself, was drafted. So, what does it actually mean, when you say that no person can be compelled to be a witness against himself? What is the importance? Does it in any way mean that there is a right of presumption of innocence? As we have understood, it is, it also means a right of presumption of innocence. Now, why would I say this? It's because in any case, when you say that no person shall be compelled to be a witness against himself, who is the witness against him? The witness obviously is the person who accuses him of it. Now, what is it when he is the person who accuses? How is it going to be framed? It is to be according to the Evidence Act again, 105. There's the burden of proof, and when there is a burden of proof and the Evidence Act is in existence, what do you see? How many presumptions are there? 114, the old 114 had a certain set of principles by way of which the presumptions could be drawn under peculiar circumstances. It does not ensure the prosecution to draw a presumption that the person is guilty. So this is how we have come to it, and this is how we understood it to be. When we gained independence and we gave our laws to ourselves with a changing scenario and the increasing incidence of women dying in their homes, 304B, Section 304B was added, and there a presumption would be there was a corresponding change in the Evidence Act by way of Section 113A, that a presumption could be drawn that if a person within 10 years, etc., has died, and certainly, it can be presumed. Initially, the courts understood it to mean that no matter what, the presumption of innocence had been dislodged on account of enactment of Section 113A. But slowly, as time went by and people started really reading into the law, they understood that actually no, it was not like this, that presumption of innocence was dislodged at the very inception, and after that, otherwise there would be no sense of a trial. If that was the presumption that is to be drawn, there was no sense. You just had to prove, certain facts, and that's about it, and the person could be convicted. But the court, in its wisdom, they gave, various directions and repeatedly said that unless the prosecution satisfies the first few safeguards or first few ingredients of the offence, you cannot draw a presumption. This having been said, unfortunately or fortunately, the court thought, our legislature thought it sensible to enact laws like UAPA and some NDPS, etc., where right at the stage of bail, you were supposed to give. You were supposed to presume the opposite of innocence. Until date, unfortunately, things were not so bad in NDPS. It was only with regard to, bail, that there was a presumption, etc., and the PP should be heard. But it didn't go, to the extent that the legislature went to in the laws of UAPA. There, Section 45, if I am not mistaken, Section 45, it goes to the extent of saying, that at the stage of bail itself, the court must come to a finding that this person has not committed an offence, and thereafter only grant him bail. Which means, that's the end of trial. You don't need a trial after that. If you're denying him bail, it means that you have believed the prosecution case as it is, and therefore the court's work is ousted. According to me, of course, the courts, I don't know why they did not object to such a appropriation of powers by the legislature, and why, they allowed the legislature to take away its powers, because otherwise, it doesn't make sense for a trial judge, when a case of UAPA goes before him, a special judge, what is what is there for him to decide? He just has to see the prosecution case, that's about it, and deny him bail. Is that, the function of a court? That is one thing. The second thing is, was the legislature in its work, right in dislodging the presumption of innocence to this extent against the international covenants and against its own constitution? That's the question. Now, the one thing that that keeps on going for the legislature is this: that we want to, presumption of innocence. Why are people so against this presumption of innocence? It's only because, they feel it's a very unfair advantage to an accused. Now look at it, from the English point of view. The English understood, that the illiterate, the Indians would have no means to prove themselves, themselves innocent, or to safeguard themselves, from assault, etc. So they kept away things like confession before a police, confession before a lawful authority, etc., out of purview of consideration. Similarly, the burden of proof was also with the state, because the state had its might, had a might of its own against, a petty citizen who probably had no means to defend himself. So that was the equation that weighed with them. Now the entire equation has changed, wherein they say that the prosecution and the accused should be put on the same level, so that the accused does not have an unfair advantage, not understanding that the accused in any case does not have an unfair advantage, because the might of the state, with all its, with its apparatus, with its whatever, it has all kinds of things, at its dispensation, that is already there with them. So whenever there is a fight between an individual and a state, it can never be equal. It can never be equal. You are always in an unequal position. And no matter here, the wealth, people think, that UAPA involves, or PMLA involves, huge amount of money, which means that the person is advantageous because of his wealth. But that may not be always correct. Wealth does not give anyone any advantage. And if wealth has to be considered, the state has much more wealth than any wealthy man. Of course, barring a couple of them, the rest, otherwise, they're always unfairly, are always on an unfair level. The second thing that weighed with the state was this, that there were too few conviction rates, and therefore the entire grind of the prosecution not being ignored, to do their work, should be given to them. So there will be a higher rate of conviction. Now when we look at the conviction rate, unfortunately the data, when you get on the net, it's very fudged. So we took out our own data, and I'll just read, where UAPA is concerned. Okay, where PMLA is concerned, between 2019 to 2024, 911 cases of PMLA have been instituted, out of which only in 42 cases has conviction been secured, which brings it to 4.61%. Where UAPA is concerned, in the conviction rate, this is very interesting. In UAPA, in the year 2018, there were 1182 cases registered, whereas only 35 persons were convicted. Only 35. The conviction rate was 2.96. Then it went to, the next year it went to 2.77. Yet the next year it went to 10.05. In 21 it went to 7.61. And 22 it dropped to 4.07%. So according to me, the state or the legislature has not, really been able to understand the dynamics of criminal law. And it is because they've not been able to understand the dynamics of criminal law, therefore, the conviction has not been secured, and it has been unfairly burdened on. It has been unfairly burdened on the accused persons. That it is because the accused persons have got so much of advantage, therefore the conviction rate is not really as good as it should have been. But when you've changed the laws, you've reversed it, then what is the result? The result is still the same. So the point is that if crime has to be stopped, you need to understand that these are the reasons why the conviction, if you think that conviction is a way of stopping people from future crimes, then there is a way of stopping it, there is a way of plugging it. And you have to take certain steps for it. Unfortunately, those steps are very long-winded or so elaborate, and you need so much of your energy to go into it, both your mental energy and your physical energy, etc., with a lot of plans, etc., that you don't want to undertake that kind of exercise. So the easy way is palm it off on the accused persons, and then be very happy that you have kowtowed to the gallery, and everybody is clapping, but nobody actually seeing the real figures as they are. You bump into any ordinary person who does not know law, and you ask him, whether a person should be given a right to presumption of innocence. His knee-jerk, response will be no. Why should a person be presumed to be innocent? So our legislature also thinks very simply in that same, at that level, instead of educating itself that there are much more, complexities involved in criminal law and criminal trial that you need to understand. For your pan wala to say कि अरे हमने तो देखा उसको गोली मारते हुए, and therefore he should be sentenced to death. It's easy for him to say it. But then the point is that there is a procedure to be followed, which has to be followed by everyone and one to all. This is not, in one particular case that you're supposed to do this or not. It's, standardized. So this kind of thing people don't understand, and probably because of this, the whole criminal law has turned itself upside down by dislodging this presumption of innocence for no reason at all. And India, I think, it has really, that way, it has lost out in its credibility that here you've gone and signed on an international document, and you're a country, you're a nation, and you go back behind it. How does it not strike you that you're supposed to do some homework of yours? You're supposed to do something more than that, merely retracting from your international obligations and then coming to this. Am I done?
Yeah, we have still time. We can use some.
I'm done.
Yeah. Thank you.
If there is anything.
Thank you very much, Madam, so nicely explained about human rights and criminal law process, British India and other things. So rest we will go for question answers and other things. So please, any questions?
Thank you.
Sorry, leadership. Ayush will give vote of thanks. Ayush, please give. Yeah.
No duty is probably as important as the duty of paying back or gratitude. So it is with words of gratitude that I would like to thank you, ma'am, for enlightening us on the facets of human rights and criminal law practice. Ma'am, the fact that you delve into data, I think one of the aspects that, regardless of what is available on the internet, the fact that you did your own research and pointed out these facts is something that is very enriching, and I think it will encourage all of us here to probably go and do further research and delve into these aspects. Apart from that, ma'am, the fact that you encapsulated such wisdom into such short session is probably a claim to your brevity and the preciseness with which probably you practiced all throughout your life, ma'am. So it is with these words I would like to thank you, ma'am, once again for delivering this lecture. Then I would like to thank Ms. Sheshagiri Rao sir for giving us this platform so that we can also learn. And lastly, thank you everyone here for giving ma'am a patient listening here. So thank you, ma'am. Thank you so much again.
Thank you, Ayush, very nicely. This is the way we are giving an opportunity to youngsters.
Yes, absolutely.
This first time she is coming and
Right.
giving, reading
Very
CV.
good.
So youngsters, so nice. So thank you very much. Now we'll go for question answers.